Hey, you trying to do my subject? Good afternoon and welcome to the Judiciary Committee. My name is Justin Wayne and I am representing District 13, which is North Omaha and Northeast Douglas County, and I serve as the chair of Judiciary. We will start off today by having members of the committee and staff do self-introduction, starting with to my right.
Megan Kilty, legal counsel. Angelina Fearless, committee clerk.
Good afternoon, Senator Carol Blood, representing District 3, which is Western Bellevue and Eastern Papillion, Nebraska.
All right. Also assisting us as our committee pages, Logan Bartek from Norfolk, who is a political science and criminology major at UNL, and Elizabeth Cole from Omaha, who is a Isabel. I said that all year and now I messed it up. Political science and pre-law major at UNL. This afternoon, we will be hearing 5 bills. We'll have one joint hearing. Oh, we're not? Okay, we'll have 5 bills. And they'll be taken up in order outside the room. On the table to the side of the room, you will have find blue testifier sheets. If you are planning to testify, please fill out a blue testifier sheet so we can have accurate record of how to spell your name. If you do not wish to testify, but you would like your present recorded in the hearing, please fill out a gold testifier sheet. Also, I will note that it's the legislature's policy that any letters of records must be submitted to the committee by noon the prior day of the hearing. Any handouts from testifiers, if you don't have 10 copies, please give them to the committee page before you come up and testify so we can have 10 copies for the committee. Testimony for each bill will begin with the introducer's opening statement. After the opening statement, you will hear from supporters of the bills called proponents. Then you'll hear from those in opposition called opponents. Following the bill, you'll hear from those in a neutral capacity. After that, we'll have the introducer of the bill, if they wish to close, make closing statements. We ask that you begin your testimony when you come up to testify by stating and spelling your first and last name. We will be using the 3-minute light system today. When you begin your testimony, the light will turn green. When it turns yellow, that means 1 minute warning, and then when it turns red, it means wrap up. I would like to remind everyone, including senators, to please turn off or silence or vibrate your cell phone. And with that, we will open the hearing on LB 581. Senator Kavanaugh, welcome to your judiciary.
Thank you. Thank you, Chairman Wayne and members of the Judiciary Committee. My name is Michaela Kavanaugh, MACHAELA-CAVANAUGH, and I have the privilege of representing District 6 in West Central Omaha. I'm here today to introduce LB 581, and I think this is my first time with this legal counsel, so hello, nice to meet you. And LB 581 creates a pilot program at the Nebraska Correctional Center for Women and the Youth Rehabilitation Treatment Center for Females to access doula services during pregnancy and postpartum. The Journal of Perinatal Education reported on research that compared 2 groups of pregnant women in the same prenatal care classes. One group chose to work with a doula, the other group did not. After all the babies were born and impacts recorded, the comparison showed that mothers matched with a doula had better birth outcomes. Doula-assisted mothers were 4 times less likely to have a low birth weight baby, 2 times less likely to experience a birth complication, and significantly more likely to initiate breastfeeding. Simply by having a doula assisting the mother, her health and the health of her infant were improved compared to the groups without a doula. I would like women in the Nebraska correctional system or in the Wire Youth Rehabilitation Treatment Facility to have access to support and healthy start for their infants. That's the genesis of LB 581, healthier moms and babies. Women in our correctional and rehabilitation systems are at a higher risk for stress-related complications and less access to normal prenatal care than would be found outside of the system. They need that extra support a doula can provide. The current nursery program is a big help for women at the Women's Correctional Facility in York, but the extra assistance of a doula would improve outcomes even more. Recently, there has been some communication about screening of visiting doulas at the hospitals. Although an amendment is not ready at this moment, I am working with the Hospital Association on crafting that amendment, and I would be happy to take any questions that you may have.
Any questions from the committee? Seeing none. Oh, Senator Decay. You literally had your hand right where that mic was, and I could not
Does
see
that
it.
mean I'm pretty thin?
Oh, man, hey, I wish I had that issue.
My apologies, Senator Kavanaugh. I couldn't hear everything real
Oh, sure.
well, so,
This room has really great acoustics.
but with that, what's all the amendment going to entail then going forward?
What will the amendment entail?
Yeah.
Well, that's what we're still working on is to fine tune the language to make sure that it's agreeable with. I brought this on behalf of Ivy Blackgirl, who will be testifying today, but the Hospital Association had some concerns, and so I want to work with both groups to make sure that we're addressing the concerns and maintaining the integrity of the bill. So I don't quite know yet what it's going to say, but I will be sure and bring it to the committee when it's available.
I appreciate it. Thank you.
Any other questions from the committee? Seeing none.
I
thank you.
will not be staying to close.
All right,
So thank you very
no
much.
problem. First proponent. First proponent. Proponent. Spike, next time don't get up when I say proponent. Like seriously, how many times have you been here? Second proponent. Are you the first proponent? Okay, you can be first. Wait, are you not? Okay, wait, I'm confused. Oh, okay. This is so confusing today. Welcome, and how are you doing?
Thank you.
Great, you're fine.
All right. My name is Alida McKell. It's spelled A-L-E-D-I-A. Last name is McKell, M-I-K-A-L-E. Chairperson and members of the community, my name is Alida McKell, and I'm here today to speak in support of LB 581, a bill that is required of the Office of Juvenile Services and Department of Correctional Services to create a pilot program for the doula services and the birthing people that are incarcerated. As a Black woman and owner of Doula Companion, I have personally experienced and seen firsthand the disparities that exist in the maternal health outcomes for Black birthing people. In Nebraska, Black women are 3 to 4 times more likely to die from pregnancy-related complications than white women, and infant mortality rates in our state are higher than the national average. The Prison Policy Initiative has reported that women in the prison have higher rates of chronic health conditions and pregnancy-related complications that women in the general population just don't have. While comprehensive data on maternal mortality rates for incarcerated women is lacking, we assume that the limited access to quality health care and support services, also the stress of being incarcerated while pregnant, would cause the rates to be even higher. Exposure to stress and trauma during pregnancy can relate in negative outcomes such as premature birth, low birth rates, and developmental delays. The trauma associated with incarceration, including separation from family and community, can worsen these negative outcomes and cause long-term health consequences. Research has found that exposure to high levels of stress during pregnancy can have a lasting effect of the developing fetus and child in their future health and well-being. Children born to mothers who experience stress during pregnancy are at higher risk for behavioral and emotional problems, cognitive delays, and learning difficulties. Furthermore, the stress and anxiety associated with incarceration can also lead to mental health challenges for the birthing person, including depression, anxiety, and PTSD. To address these issues, I'm advocating for doula services for pregnancy, labor, delivery, and postpartum. Doulas can provide emotional, physical, and educational support, which we can help reduce intervention and complications during birth. Additionally, doulas can also alleviate stress and anxiety during their postpartum and improving their birthing and postpartum for both the mom and baby. Let me skip down. I don't have as much time. Excuse me. In conclusion, I urge you to support the LB 581 and help ensure that all incarcerated birthing persons have access to doula services that can improve their mental health and outcome. We want to bridge that gap and to ensure that we have the support and resources that they need so that they have a safe and healthy birth. It is a wise investment for the health and well-being of our communities. Thank you for your time and consideration.
Thank you. Any questions from the committee? Seeing none, thank you for being here today. Next proponent. Welcome.
Thank you, Chairman Wade, members of the Judiciary Committee. My name is Andy Hale, A-N-D-Y, Hale, and I am Vice President of Advocacy for the Hospital Association. And we are in support of LB 581 with the amendment. And I'll address Senator Kay's question in regards to the amendment. The issue that we have at York General Hospital, which is the facility that would handle most, if not all, of these individuals, is we want the doula to be certified as a visitor would be going into a facility. So however the Department of Corrections determines that, we don't want to step in that, but if that individual is allowed to be in the correctional facility as a visitor, then we want the same rules to apply when they're in our hospital. Oftentimes it has happened before, not just with doulas, but individuals that are with the family. They've come to the hospital and our staff have encountered problems because it's usually a nurse that is the individual that has to tell them no, and it just causes security concerns. So we would defer to the Department of Corrections on however they want to define who this visitor is, and other than that, we have no problems with it.
Any questions? Senator Kay.
Would that doula or nurse, would that be a person that would be on call 24/7 to be available when labor would start?
Yeah, my understanding is the patient, the mother would be able to appoint that, and yes, that person would be available at that time.
If it's during their normal shift work as a nurse at the hospital, at York Hospital, would they be being compensated by York Hospital or by the Department of Corrections?
I don't know who would compensate the doula. I guess I'd have to look into that question. I'm not sure that process of how that would work.
Right. Thank you.
Any other questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent. Welcome.
Thank you. Good afternoon, Chairperson Wayne and members of the Judiciary Committee. My name is Anahi Salazar, ANAHISALAZAR, and I am representing Voices for Children in Nebraska. Every child deserves to experience healthy, loving relationships from the moment of birth, and every mother deserves the support we can offer to foster and sustain their relationship. Voices for Children supports LB 581 because it creates a pilot program for doulas in the Youth Rehabilitation Treatment Center, or YRTC, Hastings, for young mothers and their newborns. Pregnancy and childbirth are emotional and impactful experiences for mothers. A trained doula is a trustworthy person who provides emotional, physical, and informational support to the mother before, during, and after birth. Doulas have the unique opportunity to support women throughout their pregnancy, starting with prenatal information and care, through labor by helping provide positive birth experiences, which help create positive health outcomes and fewer complications and interventions. And lastly, with postpartum care, supporting women in what can be referred to as the fourth trimester, as well as looking for signs of postpartum depression. LB 581 creates a doula pilot program because it recognizes the importance of preserving prenatal relationships for both mothers and babies. Mothers, even those in facilities, deserve a positive pregnancy experience with the expectation that they will be able to bond with their child. We should do everything we can to ensure the pregnancy experience and bonding and preservation of families when mothers are committed for residential treatment. For young mothers, the unfamiliar environment of a hospital can be stressful and frightening. Most girls at YRTC are far from home and family who could provide supportive care during and after labor. Giving birth can be a traumatic event that shouldn't be experienced alone or without experienced support. Ensuring a healthy and supportive birth experience for young mothers who are in the YRTC can help maternal self-esteem and foster a thriving relationship from day one. This is especially important because girls in YRTC are within the juvenile court system, where all systems should be aimed at their rehabilitation and best interests. And services at the YRTC should be aimed at holistic wellness for when they return home. For a girl becoming a new mother while at the YRTC, the potential impact of a doula to provide care and support cannot be overstated. Currently, there are a number of states that offer doula support for incarcerated mothers, such as Minnesota, Georgia, and Michigan. Nebraska should also be doing all it can to support mothers and their newborns. We would like to thank Senator Michaela Cavanaugh for her leadership on this important issue and the committee for your time and consideration. Thank you.
Thank you. Any questions from the committee? Seeing none, thank you for being here. Next proponent. Welcome.
Thank you. Chairperson Wayne and members of the Judiciary Committee, my name is Kelsey Ahrens, that's KelseyArens, and I'm the Healthcare Access Program Staff Attorney at Nebraska Appleseed, testifying in support of LB 581 on behalf of Nebraska Appleseed. We are a nonprofit legal advocacy organization that fights for justice and opportunity for all Nebraskans, and one of our core priorities is ensuring that all Nebraskans have equitable access to quality, affordable healthcare. Because LB 581 promotes equitable access to healthcare, Nebraska Appleseed supports this bill. For many years, the maternal mortality rate in the United States has consistently worsened and exceeded that of other high-income countries, and the U.S. has particularly high mortality rates for Black pregnant people. Pregnant people who are incarcerated are also particularly vulnerable to poor health outcomes. A disproportionate number of people entering correctional facilities have chronic, undetected, or unaddressed health issues. It's crucial to ensure correctional practices address the health needs of those who are giving birth while incarcerated. Making doula care available to those who are incarcerated can improve health outcomes and result in cost savings. Evidence indicates that doula care can improve health outcomes and birthing experiences for both the pregnant person and the baby. Evidence has shown that doulas reduce the need for medical interventions like cesarean delivery, which are riskier for pregnant people and for babies. Continuous labor support provided by doulas also improved 5-minute APGAR scores for infants. Additionally, doula care also has the potential to reduce healthcare spending overall. Doula care's reduction in cesarean births alone can reduce costs, but doula care may also reduce costs by preventing birth complications for pregnant people and their baby. For these reasons, we respectfully request that this committee advance LB 581.
Thank you. Any questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent. Welcome.
Thank you. Hi, my name is Scout Richters, SCOUT-RICHTERS, here on behalf of the ACLU of Nebraska. Birth equity for incarcerated Nebraskans fits squarely at the intersection of the ACLU's work to support the reproductive freedom of all Nebraskans, as well as our work to ensure that Nebraskans who are incarcerated are treated with dignity and have access to life's basic necessities. Thanks to Senator Kavanaugh's work in this area, LB 690 passed in 2019 and prohibits the shackling of pregnant and postpartum people who are incarcerated. LB 581 builds on these efforts to ensure safer deliveries, healthier outcomes, and less traumatic births for Nebraskans who are incarcerated by offering doula support for those who go into labor while they're in state custody. From time to time, the ACLU receives intakes from pregnant Nebraskans detained in our county jails and state prisons. We've actively investigated claims of mistreatment and civil rights violations for incarcerated pregnant women, successfully litigating one such case, and investigated concerns about the childbirth process in at least one instance. Doulas provide individualized care and education about pregnancy and childcare and ways to reduce stress and promote a healthy pregnancy. This is particularly important for pregnant Nebraskans who are incarcerated, a disproportionate number of whom are Nebraskans of color, because people of color, as you heard, face maternal mortality rates nearly 4 times greater than their white counterparts. So as such, we offer our full support for LB 581, and I urge the committee to advance this bill.
Any questions from the committee? Seeing none, thank you for being
Thank
here today. Any other proponents? Welcome.
Good afternoon, members of the Judiciary Committee. My name is Naomi Thompson. That's NYOMITHOMPSON, and I'm representing IB Black Girl. IB Black Girl serves as a collective for Black women, femmes, and girls to actualize their full potential to authentically be through autonomy, abundance, and liberation. I'm testifying in support of LB 581. Pregnant people who are navigating incarceration are among the most disregarded populations in the United States. These individuals have unique and significant healthcare needs which affect them and their family's long-term well-being, yet are being overlooked. A majority of The women's prison population are parents and of reproductive age. In particular, 82% of Black women navigating incarceration fall into this population, which has strong implications of the importance of adequate and equitable reproductive care. Regardless of being incarcerated, Black women and people with the capacity for pregnancy have higher rates of mental health conditions, chronic illness, and a higher likelihood of dying from birth than other racial groups. This can be attributed to the documented and continued impact of systems of oppression, implicit bias, and unequal treatment of Black women. Black women having to navigate incarceration only increases these disparities, resulting in the following. 4 out of 5 people experiencing incarceration report having depression or anxiety. 63% of women in both prison and jail report having a chronic condition. And according to the CDC, incarcerated Black birthing folks are 3.5 times more likely to die during childbirth compared to white birthing folks. An opportunity to improve maternal health outcomes for incarcerated population is expanding access to doula care. Research has correlated doula care with a 64% less chance of experiencing postpartum depression and anxiety, and increased ability to bond with their newborn, fewer C-sections, and fewer low birth weight babies. In addition, doulas reduce the harmful effects of racism by providing culturally appropriate patient-centered care. This is an issue that not only directly impacts the birthing person and infant, but transcends into Black families and communities. We ask you to support the reproductive and birthing experiences of Black birthing folks and move LB 581 to the next step of the legislative process.
Thank you. Any questions from the committee? Seeing none, thank you for being here. Next proponent. Proponent. First opponent. Any opponent? Welcome.
Thank you. Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Diane Sabatkarain, D-I-A-N-E, S-A-B-A-T-K-A-R-I-N-E. I'm the Interim Director of the Nebraska Department of Correctional Services. I am here today to provide testimony in opposition of LB 581. Our primary concern with this bill is the security risk that certain provisions pose to our facilities and the community. This bill excludes consideration of prior convictions or current supervision status when determining if an individual is appropriate to provide doula services. This circumvents the department's oversight for determining who is authorized to provide services at our facilities. Since these individuals would have access to various locations within the facility, the department needs to be able to provide oversight for doulas in the same way we would with volunteers, to include reviewing their background to ensure they are appropriate for this undertaking. LB 581 would also put the department out of compliance with the Federal Prison Rape Elimination Act, or PREA standards, which require correctional agencies to perform a criminal background check before enlisting the services of any contractor. The PREA standards also prohibit correctional agencies from enlisting the services of any contractor who may have contact with inmates if the individual has committed certain disqualifying acts. Furthermore, to implement this bill, NDCS would need to notify the doula when prenatal visits or cesarean section is scheduled. Providing people outside the department with advance notice of scheduled appointment times creates a significant security risk when transporting inmates outside of the facility. Additionally, the bill says that pregnant inmates shall be permitted access to a trained or certified doula, but it is unclear what training or certification is sufficient since we've been unable to identify any state standard or certification for doulas. Currently, similar types of services to those discussed in this bill are provided by NDCS nursing coordinator, other NDCS staff, or hospital staff. The assistance currently provided meets the intent of this bill without proposing the same safety and security risks as LB 581. Thank you for the opportunity to testify today, and I would be happy to answer any questions that you have.
Any questions from the committee? Senator McKinney.
Thank you. Do individuals with prior, convictions or things on their record currently volunteer inside the institutions?
We do have some volunteers who have past criminal records. We also have some of our volunteers that are approved to come in and provide services that remain on parole.
So what are the disqualifying acts that would prevent somebody?
So from a PREA standpoint, they are primarily any of those sex-related offenses that people have in their past. So Burglary might not be a disqualifying event. A sexual assault could be.
So if Senator Kavanaugh proposed an amendment that would allow for background checks and exclude anybody with any previous sexual convictions on their record, would you still be in opposition?
I think that if an amendment allowed for us to do screening similar to what we do with visitors or other volunteers or contractors, that would address part of it. The other security issue that exists for us is notifying volunteers or service providers in advance of scheduled medical appointments in the community. Anytime we transport an inmate outside of the facility, there's just a security risk that goes along with that. And so generally that information is considered confidential and not widely shared. So that concern would still exist.
So what's the medium to that though? Where's the medium?
I think the medium might be that the doula service could be provided for certain events, but perhaps not all of them. So
Well,
again, well, if you have a routine medical visit scheduled, we couldn't give them advance notice of the routine medical visit. And I don't know that they would necessarily have the flexibility to just, once they've arrived at the destination of that medical visit, that we could reach out to the doula and say, come in now. I think that that might be burdensome for them. So those are the parts of this that would be pretty challenging from a security aspect to address.
So if an individual is going into labor, would that be okay?
So once the individual arrives at the hospital and they're present there, then a notification is possible, I believe.
So what's
But
the usual timeline once somebody is transported from the facility to the hospital that you alert anybody that they're at the hospital and they're in labor?
So the usual timeline for departure from the facility to the hospital?
No, like, so if somebody currently goes into labor, do you alert the family or somebody that, hey, X person is at this facility in labor?
We
what's
would
that?
notify them once they're at the hospital.
Okay, so once they get to the hospital?
Yes.
Okay. So the language probably could be, we'll alert the doulas once they get to the hospital?
Correct.
Okay, thank you.
Okay.
Any other questions? Senator DeKay.
At the facility, is there, when you talk about routine medical appointments and stuff, is there a pediatrician after the baby's born and stuff that's on staff at that facility, or do they have to go to a clinic for those?
So we don't have a pediatrician on staff at the facility, but we use those providers that are available in the York community primarily.
Are most of the doulas that come in, are they, as earlier testimony, are they more of could they be on a registered nurse, or they could just be an individual friend, family member, or whatever that could be in that capacity?
So I don't think we have any doulas that are currently being used at the Nebraska Correctional Center for Women. And my understanding is that doulas do not necessarily have to have a nursing degree, but rather there's other training and certification available to them. But I might not be the best person to ask about their training.
But when they come into the facility to act as a doula, then they have the same restrictions coming into the facility, the background checks and stuff, as a regular visitor would at that point, or would there be more stringent?
It would be very similar to a visitor or a volunteer or contract provider that exists currently.
All right, thank you.
Any other questions from the committee? Seeing none, thank you for being here.
Thank you.
Any other opponent? Any other opponent? Welcome.
Good afternoon, Chairman Wayne and members of the Judiciary Committee. My name is Sarah Morgan, SaramorGan, and I'm the Deputy Director of Health Promotion and Prevention for the Division of Public Health within the Department of Health and Human Services. I'm here to testify in opposition to LB 581, which proposes to require the Office of Juvenile Services to create a pilot program for doula services at the Youth Rehabilitation and Treatment Center, and to require the Department of Correctional Services to create a pilot program for doula services at the Nebraska Correctional Center for Women. There's currently no state regulatory authority over doulas and no requirement for criminal background checks. The absence of a credential in Nebraska is a concern for public safety, as there are no specific education or training requirements by the state to standardize a doula's education, competencies, skills, or services provided. Furthermore, LB 581 states that a doula cannot be denied eligibility solely on the basis of a prior criminal conviction, or if the doula is currently on pretrial release, probation, parole, or post-release supervision. This requirement of the bill is in direct conflict with our state background check and Federal Prison Rape Elimination Act, PREA standard 28 CFR 115.17 for hiring and promotion. This standard prohibits the hiring or promotion of any individual who may have been convicted of or engaged in sexual abuse in a prison, jail, lockup, community confinement facility, juvenile facility, or other institution. The PREA standard requires a background check and abuse registries check at hire and at subsequent points during employment, as well as provides a means for individual self-reporting of convictions or prohibited activities. Any omission of reporting misconduct will result in the termination of the employee. This is a federal standard that adds significant protection for this vulnerable population. I've included a copy of the PREA standard as an attachment to this testimony for your review. DHHS respectfully requests that the committee not advance this legislation. Thank you for the opportunity to testify today. I'm happy to answer any questions.
Thank you. Any questions from the committee? Senator Glenn.
Thank you, Chair Wayne. Thanks for coming in today. Since you are in public health, I just have a quick question. Explain the difference to me between a midwife and a doula.
Well, because the doulas don't have a standard for the training and education that they go through, it can vary significantly depending on what organization offers those services. It's very difficult to say overall what types of skill set every doula has. Typically, doulas offer a lot of emotional support for the pregnant woman prior to and then during and potentially after the birth event. And I think previous testifiers have discussed already some of the benefits that can come from doula services. But again, that lack of standardized training or education is where it becomes difficult.
How do we know if there's a lack of training? What do we base that?
Lack of standardized training, I'm sorry.
Okay, that makes a lot more sense to me. Again, though, how do we know that you're lacking standardized training? You mean standardized training that we put in place?
Yes.
So we do have the ability to put that in place.
Yes.
All right, thank you.
You have a question? Senator McKinney.
Thank you. What's the demographic of doulas usually?
I'm sorry, could you?
What is the demographic of doulas usually?
The demographics of doulas?
Yeah.
I don't believe I can answer that question for you, Senator. I'm sorry.
And what would be the benefit of a standardized test?
Our concerns are around making sure that any individual who has access to this vulnerable population has a certain amount of competency and skills that the state has reviewed and allows for that background check.
So do you not think doulas currently have the competency?
Again, there's no standard education or certification for doulas right now, so one doula could have a vastly different training experience from another.
So would you be less in opposition if the PREA standards were applied to this bill?
I think if there's an amendment that's been offered, we'd be happy to look at that specific language and give you feedback.
All right, thank you.
Any other questions? Seeing none, thank you for being here. Next opponent. Seeing none, he may testify in a neutral capacity. Seeing none, Senator Kavanaugh has waived closing We have 18 letters for the record, 4 in support and 14 in opposition. Now to close the hearing on LB 581. We will open the hearing on LB 89. Senator Hunt, welcome to Judiciary. Wait a second, let me clear out. Welcome, Senator Hunt.
Good afternoon, Chairman Wayne and members of the Judiciary Committee. I'm Megan Hunt, MEGANHUNT, and I'm here to present LB 89, a bill about removing barriers for Nebraskans who want to start or grow their families. Over the summer, I was meeting with a constituent who mentioned that because of current statute, Nebraska is considered a surrogacy-unfriendly state. That surprised me, so I looked it up and I found that we have this statute, and it says in Nebraska, surrogate contracts are unenforceable by courts. Upon looking into this more, I became interested in why Nebraska would have this law, so here's a quick history. The bill that created this law in 1988, LB 674, was introduced by Senator Chambers. His intent was to prevent Nebraska courts from exercising jurisdiction over surrogacy contract disputes that might arise in a time when surrogacy was becoming more popular. I read some of his testimony, and in it, he noted that the bill does not make surrogacy contracts illegal. That is, it does not prevent people from choosing to make a surrogacy arrangement and abiding by the terms of that arrangement. But courts having the authority to enforce these contracts, he said, would result in stripping the rights of intended mothers. In bringing this bill, he came from the perspective of being a descendant of, as he put it, people who were bought, sold, and bred like livestock. And in the debate on this bill, he spoke to how being a descendant of slaves gives you a keen sensitivity to the commodification of human beings. Surrogate agencies, he warned, stood to profiteer off the exploitation of poor women of color who would never be able to have their own surrogates, while rich white women would always be able to. And he basically said this was a tool available to rich women to use poor women of color as breeders. I have an immense amount of respect for Senator Chambers, but I respectfully disagree with him here, though I honor that he came from a different position in a different set of circumstances, and that the world was also different when this bill was passed. I think he had some ideas about this bill that I don't agree with anymore in this present day, and I don't think that the law really holds up anymore. For example, Senator Chambers had a problem with surrogacy agreements in general, and his opinion, at least at the time, was that biological fathers ought to also be required to assume responsibility for the child they create via surrogacy. He also compared traditional surrogacy, in which a woman is impregnated directly with the gametes of the genetic father, to adultery, and said that couples unable to have children should adopt rather than arrange a surrogacy, which would commit adultery. I'm taking a different view on this because I think that it's not our role as lawmakers to bar Nebraska families from making choices that work best for them. And I think it's fair to leave any surrogacy dispute up to the courts. There have certainly been biases in our court system, but to render these surrogacy agreements legally null and void means that any couple or parent wanting to be involved in a surrogacy arrangement has no legal protection of their rights or enforcement mechanism if there is a disagreement. A lot has changed in the realm of surrogate parenthood since 1988. Surrogate parenthood is now used in many circumstances, such as major health issues of the mother, same-sex couples seeking to have children, individuals who want to be a parent, and couples struggling with infertility. The choice to be a surrogate or to use a surrogate for one's child is a deeply personal and emotional one. As with nearly everything significant we humans do, there are risks of emotional or physical complications. I think that we do Nebraskans a disservice by saying that any surrogacy arrangement has to be informal and on the honor system, and that there is no recourse if the intended biological parents, and the biological parents don't agree on something. I will note that in my review of the history of Senator Chambers' bill, no one testified either in favor or against this bill, and no senator debated against the bill on the floor. So it seems like it was a personal passion of the senators and not something that arose out of constituent demand or test cases that showed it was necessary. A major problem with current statute is that courts will only grant parentage orders to genetic fathers, meaning the spouse or partner of that father has to complete an adoption in order to establish parental rights, whether or not they are genetically related to the child. So with LB 89, we strike that statute that says surrogate contracts are void and unenforceable, and there's also a stricken provision in there that grants automatic parental rights to the biological father. That piece was included in the law because of Senator Chambers' view that if the child resulting from a surrogacy was somehow found unsatisfactory or was no longer wanted by either the intended parents or the biological parents, that someone ought to be responsible for providing for it, and he thought that should be the biological father. By striking the unenforceability of contracts provision, we cover for this circumstance by allowing couples to clearly outline the terms of what should happen in these situations beforehand in a legal contract. The Pew Charitable Trust did a review of state surrogate policies, and there are stories of surrogates who work with agencies being asked to sign contracts saying they won't go to a handful of states with these prohibitions, including Nebraska, because if a child is delivered here, it would be difficult to transfer custody to the intended parents. Many surrogates surveyed for the brief said that they want legal protections to ensure the intended parents take the baby, regardless of any birth defects or change in their own life situations. So this protection is beneficial for both the surrogate and the intended parents. There is an amendment on this bill, AM 203. I filed it in February. I brought this amendment after getting some feedback that I agreed with, that the bill should include some kind of protection for the health of the surrogate if a life-threatening situation arises. I heard examples where sticky situations came up mid-pregnancy, such as a woman who got a diagnosis of late-stage cancer and needed to start treatment as soon as possible to prolong and save her life. But this posed a threat to the pregnancy, and the intended parents threatened legal action if the woman were to seek cancer treatment, even though her life was at risk. With AM 203, the bill would say surrogates can't be legally held liable if they have to make choices about whether to receive medical treatment to protect their own health and safety. The language is borrowed from similar exemption in Texas's surrogacy law. I want to leave you with an excerpt from a Creighton Law Review paper that looked at the history of this policy and its impacts. It concludes, the unicameral should re-examine the social policy behind the law, especially considering the lack of debate in the law's passage and recent technological advances. Nebraska's law presumes complications that may not in fact exist and does not address surrogacy arrangements beyond those existing at the time Nebraska legislators passed the bill. The law review goes on to say that the unicameral should provide certainty for those entering surrogacy contracts, and that even a flat prohibition of surrogacy contracts with criminal penalties would provide more predictability than Nebraska's current scheme. Surrogacy contracts should be recognized to allow for individuals to create families in a way that makes the most sense to them. Those with medical conditions, those with infertility, those who are in the LGBTQ community deserve the opportunity to raise children if they want to. For some parents, surrogacy is the best opportunity to experience parenthood. There are many various pros and cons to why a family might choose surrogacy versus adoption, and I think Nebraskans should have that choice. LB 89 with AM 203 would protect the rights of intended parents who are ready to start or grow their families while also protecting the life of the surrogate. Both are important. Thank you.
Any questions from the, thank you. Any questions from the committee? Senator Decay.
Good afternoon, Senator Hunt. We say the baby's born, you have the surrogate and you have the parents that are going to have, and both of those parties decide they didn't want that baby after it came to earth. What are the protections for that baby going forward, and how would that be handled? Would that be handled through an adoption agency?
Well, what this bill would do is actually put more protections in place for that baby, because it would allow an enforceable contract that stipulates what the intended parents and the biological parents want to have happen should that be the case. As it stands today, I mean, the baby would just become a ward of the state immediately, basically, and because any contract between them wouldn't be enforceable.
Thank you.
Any other questions from the committee? Seeing none,
Thank you.
thank you. First proponent. Proponent. Welcome.
Hello, thank you. My name is Emily Gehling, E-M-I-L-E-E, Gehling, G-E-H-L-I-N-G. And I am here to speak in favor of LB 89. I'm a lawyer. I've been practicing in this area of assisted reproductive law for about 13 years. It's my privilege and honor to have represented hundreds of intended parents and hundreds of gestational surrogates on the other side in their surrogacy arrangements. I practice in Nebraska, Iowa, and South Dakota, so I'm familiar with 3 very different legal approaches to surrogacy arrangements and parentage orders. Intended parents that I work with have been cancer survivors, just general infertility. 1 in 8 couples in the United States suffer from infertility, so it's actually a lot more common than you may even think. My intended parent clients have explored many opportunities to build their family, and adoption, a lot of them have had failed adoptions where the birth mother changed her mind. When some of them, it's important to them to have a genetic child. So I'm speaking in particular to gestational surrogacy, where the person carrying the child, the birth mother, is not in any way related to the child, is actually the embryo belonging to the intended parents. On the other side, gestational carriers that I've represented have been very educated, smart women, nurses, dentists, stay-at-home moms, paralegals, people who just have a very large heart and want to help another family with their family building. I also have co-founded a South Dakota surrogacy agency, so I have that background as well. The attorneys, the clinics, and agencies follow a lot of best practices and guidelines from the American Society of Reproductive Medicine. I'm also a fellow of the American Academy of Adoption and Assisted Reproductive Technology Attorneys. And the law as it stands creates uncertainty for people who are trying to go through this process and build their families. It also protects the gestational carrier, parents, and the child to make sure that all 3 of them, their best interests are looked at and protected. And I urge you to vote in favor of LB 89, and I'll be here and available for questions if there are any.
Thank you. Any questions from the committee? Seeing none, thank you for being here. Next proponent. Welcome.
Hello, my name is Rachel Middleton. It's RACHAELMIDDLETON. And I just want to thank you for letting me come here and speak. I'm actually a gestational carrier for 2 wonderful and deserving couples, a woman named Lou and a husband named Liv. And I'm here today to hope that we can progress our laws on surrogacy to better help those who are in need of being able to have their own child. Most of the people that are seeking gestational carriers have gone through all the options. They've gone through tons of heartache and loss and struggles, trying to conceive their own biological child. And I feel like they should have the right to have that. And gestational carriers provide that for them. I wouldn't be genetically linked to this child at all. I would basically be a babysitter or like just someone that's watching and taking care of this child for those 9 months. That way I can hand them their baby at the end of that time. I think it would just be a wonderful thing to see their faces. I don't know if any of you have children, but when you saw your child born for the first time, just just you wanted to protect them, you would do anything for them, and these parents are trying to do something like that, and I think it would be a wonderful thing to do. And I think they should have the right to be able to do this safely, and the LB 89 would allow them to be protected along with me being protected as a surrogate. That way, when one of you guys asked about what would happen if someone didn't want the child, most of the time that's not going to happen. These people fought so hard to get to where they are to have this child, and it would at least make people responsible. If for some reason something like that would come up, a contract would help protect everybody involved, especially that child. I think just after suffering so much loss, and the science, faith, and hope would let this be possible for them, and then Nebraska would allow LB 89 to be approved, and we could have contracts to just protect everybody. I think it just made people feel more safe and protected, and they have rules. When she mentioned the ASRM guidelines, you have to be psychologically evaluated. Both sides do. You need to have background checks. You have to be medically cleared. You have to not be on any government assistance. It's very important so that way no one's being taken advantage of. There's so many rules that they put in place to help everybody to follow, and then a lot of clinics, the reproductive endocrinologists follow those. They want to make sure they have had a child, a healthy pregnancy. They're actually taking care of that child that was not given away. And so there's lots of things that go into this, and not just, oh, I want a child. So I'm out of time, but I would really urge you guys to pass this. Thank you.
Thank you. Any questions? Senator Grice.
Just a quick one. Since our state doesn't recognize these contracts, is this done without a contract?
So you
often?
still have attorneys. You each have your own attorney, and then they make a contract together. But it's kind of one of those, you're trusting each other that you're going to abide by those.
Good faith.
A good faith, yes. So I've had to put a lot of trust into this couple, and they're putting a lot of trust into me.
Okay, thank you.
Yep.
Any questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent.
Hi, Scout Richters, SCOUTRICHTERS, here on behalf of the ACLU of Nebraska in support of LB 89. The ACLU of Nebraska believes that procreative decisions concerning whether, how, and when to bear a child are private and protected decisions, and that the state has no compelling interest in involving itself in an intimate, private arrangement between consenting parties seeking to have a child. All Nebraska families deserve the opportunity to control our lives at the most basic level, our bodies, our families, and our life's path, including if that path involves becoming a gestational carrier or welcoming a new family member via surrogacy. It is important to recognize that families are formed in a variety of ways, as Senator Hunt mentioned and the other testifiers, and Nebraskans need the autonomy and freedom to be able to make the decisions that are best for themselves and their families. So with that, we thank you, and we ask the committee to advance this bill.
Any questions from the committee? Seeing none, thank you for being here. Next proponent. First opponent. Welcome.
Thank you very much, Chairman Wayne and members of the Judiciary Committee. My name is Marion Miner, M-A-R-I-O-N, M-I-N-E-R. I'm here on behalf of the Nebraska Catholic Conference, which advocates for the public policy interests of the Catholic Church and advances the gospel of life through engaging, educating, and empowering public officials, Catholic laity, and the general public. The conference opposes LB 89 as introduced and as amended by AM 203. As originally introduced, as Senator Hunt stated in her opening, LB 89 would strike Statute 25-21200, a statute passed into law after its introduction by Senator Chambers in 1988. As Senator Hunt also mentioned, it was meant to combat what Senator Chambers described at the time as the commodification, or another word that he used was the thingification of human beings. On similar grounds, many countries, including Austria, Finland, France, Germany, Italy, Norway, Portugal, Spain, and Switzerland, among others, prohibit surrogacy entirely, as contrary to the dignity of women and to the dignity of the family. Many more countries allow altruistic or non-compensated surrogacy, but prohibit compensated or commercial surrogacy for that same reason. Even where there is consent on both sides to carry another person's child, the practice of surrogacy is problematic because of what it does to that child. A child cannot consent to be one of the vast majority. A 2010 study said more than 90% of embryos who do not survive the IVF process, which is what's always entailed in gestational surrogacy. A child cannot consent to being made into an article of exchange. Both the introduced and amended versions of LB 89 impose those injustices on a child by recognizing surrogacy contracts as enforceable. Surrogacy treats children as products which can be purchased and delivered to adults who can afford them, and sometimes also entails the rejection of children, leading to abandonment or coerced abortion if the intended parents receive an unfavorable diagnosis. This is something we've seen in other parts of the world. This is not only dehumanizing to the child, the knowledge of it also impacts the child's sense of identity and his or her family relationships. I have more. I was not able to get this out to hand out to you so you can see it today. If you'd like citations of what I've cited, I'm happy to provide them. But I will close there simply in stating we're opposed to the bill because we are opposed to the commodification of human beings and the making of human beings into objects entering into the stream of commerce as objects of exchange. So with that, I'll conclude my testimony, and thank you for your time.
Thank you. So if there were you can't exchange money, there can be no value exchanged, would that change the position?
That would be better. There is, I think there would still be issues with that, but that would certainly be better. That would solve the problem at least of exchanging human beings for compensation, which is a big problem. But we're also talking when we're zooming out and looking at the child and the child as a person and therefore a bearer of rights. We also have to think about what is in the best interest of that child and what rights that child has with regards to their own procreation, how they come into being, and to their parents.
That's a kind of a strange thing. Like, does a person have a right to how they came to be?
It's not something that you can fix, in retrospect, but yes, a person does have. I understand why it's kind of an odd thing to try and conceptualize, because you're talking about somebody who doesn't yet exist and may come into existence.
So when does the right get conferred on a person? Because if they can't exist but for this, then they can't have a right.
Sure. Yeah, I understand that. So, but.
Okay. So
here's maybe a better way for me to help frame this. So, a child can't help but be born into whatever circumstances they're born into.
Which is already true.
Right. So, but a child does we owe it to children to ensure, if we can, where possible, that when they come into the world, it's in a situation that's going to be best for their flourishing and best for their own sense of identity.
I don't know. That starts to get I start to get really nervous when I hear that, like we're going to choose legally what kind of people can become parents and in what circumstances they can become parents.
Sure. Yeah, I get that. And that's not
that makes me real nervous.
That's not where I'm trying to go. Where I'm trying to go is simply to say, human beings have certain rights. Among them is the right to life. That's already implicated in this whole process. Another one of them is the right to their own parents and to a relationship with their own parents. And it's different to make the best of circumstances that are not great after the fact It's another thing to create those circumstances in the first place on purpose.
But arguably, a surrogate would have parents that are like, the parents want this child. The parents are creating the existence of the possibilities for that child. They will be united with this child. It is not saying anything about that. It is talking about whether or not there is a legally binding contract for what can already occur. I mean, there's, if we want to get into it, biblical precedent for this, right? I mean, think about when Abraham couldn't have a child. What does Sarah say? Use my maid. Let's have a child. I mean, so there is different ways of imagining how parents come to have children. Anyway, this is beside the point. I understand now the bigger problem for you is the commodification through the exchange of money. Got it. Thank you.
Thank you.
Any other questions? I was gonna start humming church music if you was gonna keep going, so anyway.
I stopped.
Anyway, any other questions? You, at the end of the day, though, it's the, for lack of a better term, I call it IVF, but I can't think of the name right now because I'm tired. I mean, that's the, besides the commercialization, that's the part.
That's one element of it, yes. And we've come and spoken about that issue.
Oh, I know, it's my bill.
Specifically, yeah.
You were against it.
And, right, I mean, and, you know, I'm, of course, we are willing, of course, to have that larger conversation with anybody at any time. But that's simply one element of what makes this problematic. I think the real concern in terms of recognizing contracts for surrogacy, one of the really big concerns is the commodification of human beings through the exchange of goods.
Senator Black.
Thank you, Chair. I'm sorry, I keep hearing this word, and I need clarification, please. Modification.
Sorry, co-modification.
So that's the problem with this room. I kept hearing modification, and that made no sense.
Okay.
All right, thank you.
You're welcome. Thank you.
Any other questions? Thank you for being here.
You're welcome. Thank you.
Opponents? Any other opponents? Anybody testifying in neutral capacity? Senator Hunt to close, and as she comes up to close, we have 21 letters for the record, 4 in support, 16 in opposition, and 1 in the neutral capacity. Senator Hunt waives closing. Oh, I guess I'm next.
Senator Wayne, you are recognized now to open on your LB 23. Welcome to your Judiciary Committee, Senator Wayne.
All right. Thank you, Vice Chair DeBoer and members of the Judiciary Committee. My name is Justin Wayne, JUSTINWAYNE, and I represent Legislative District 13, which is North Omaha and Northeast Douglas County. This bill I have brought for the last 5 years out of a case I had in juvenile court. I'll walk you through the case and you'll see the problem that I'm trying to solve. A young woman left a domestic violence situation in Alabama. Actually, I didn't even remember what this bill was about until I just read it about 15 minutes ago because I have so many bills. Young woman left Alabama from her abusive husband, came here to Nebraska, lived here for approximately 5 years, got caught up in some drugs, had a child. In the state of Nebraska, which you've heard, this committee has heard, we have a presumption that if you are married, the child is part of the marriage. This child was immediately placed in juvenile custody because he tested positive for meth when he was born. Mother identified the father as somebody else. the father tried to intervene, but cannot because there is a presumption of the father being the husband who she left 5 years ago who was abusive. There is no dispute in the record at that time that clearly this other person was the father. Even the caseworker agreed. So the judge in this juvenile case appointed me to figure out a way to allow this person to intervene on his behalf. We tried to intervene, but there was no basis for this person to intervene. Although the court always can do what's in the best interest of the child, when it comes to intervene, in particular, there has to be some kind of biological connection. The worst part of it was the judge could not order DHHS to perform a paternity action because the law already presumed the father exists. So what would have to happen is we would have to track down the father in Alabama, and he would have to take a DNA test to prove that it was not his, so he can disestablish paternity before the court could do it. Well, there was no way to do that. So this individual could not intervene, and that's where we left it. I could talk about the appeals and all that, but it doesn't matter. That's just the law. And so for 5 years, this bill has been brought, and I'll just turn to the fiscal note. We are supposed to be a state that is pro-family. If you read the fiscal note from HHS, it literally says, it could result in the rise of cases where a legal father already established, but a genetic test identifies someone else as a biological father. That is the point. So they can't determine the cost because right now they just blanket deny that. Now there are some judges, at least in Douglas County, who are operating, they're coloring a little beyond the lines to make sure this happens. But there's no way for them to force HHS to pay for the DNA test, and there's nothing else you can do. So, trying to fix that problem. And I've been trying for a while. And as you know, as this year, if you don't have it on a priority, it usually doesn't get done. So, that's where we are. I'll answer any questions. Senator, oh, not my call.
That's my job right now.
I ignored him. Senator. Thank you, Vice Chair DeBoer. Would you be open to an amendment that also changes the word wedlock? Because that is such a antiquated word meant to mean matrimony, and it seems to be connected to words like, and I don't support these words. I'm saying this
I understand.
for a reason. Words like bastard.
Right. No, I'm fine with any amendment, and I'll tell you on page 3 of the bill, bill drafting in their idea to update the words, use the word intervener in section 3, and that cannot be, because you can't be an intervener until you actually have somebody to determine you to be an intervener.
Right.
So what would happen is the Supreme Court could say, well, the legislature already made them an intervener, and that's not it. It's a fine because they have to provide an affidavit at the time. So yes, I'm open to an amendment. We would already have to make an amendment on section 3.
Thank you.
Or paragraph 3.
Any other questions from the committee for Senator Wayne, Senator DeKay?
In the DNA testing, if the father that says he claims to want to be the father, if he was willing to pay for DNA testing, is there a law or anything in statute that says that he can't?
No, but you still run, no, it doesn't. You can pay for it. The issue is still they can't intervene because they're not the legal father in Nebraska. So as much as HHS has opposed this in the past because of the cost, that's never been the issue. It's really the legal problem of not being able to intervene because you still have a father that is recognized by the state, and you can't have 2 fathers in this state. So in the case that I was speaking of, is the father actually wanted to take the child and tried to take the child, but they couldn't even place him because there was an actual other next kin of placement from the mother. And since he is considered a stranger to the kid in the eyes of the law, the kid actually went to a stranger who was the aunt instead of his biological father.
Thank you, Senator Decay. Are there other questions? Senator Wayne, is the problem that because they haven't intervened in the case, they can't be recognized as the father? Or is the problem that they don't even have the ability to get a DNA test from a child without having, is the problem getting the DNA test? Or is the problem, what is the problem?
The problem is getting the DNA test.
Yeah.
So the issue is a stranger can't walk into court and say, test this kid, he's
Right.
mine. Even with, in this case, there was actually an affidavit from both the father and the nurse at the hospital when the kid was born saying they were here. So yeah, you can't even require the court to do a DNA test. Now, again, some courts are still doing it, but they're coloring a little outside the
So
lines.
the problem is that you can't establish the paternity through a DNA test because you can't take the sample from the child to get the test, to get it recognized. Is that right?
Correct.
Okay. Thank you. Any other questions for Senator Wayne? Thank you, Senator Wayne.
Thank you.
First proponent. Is there anyone who would like to speak in favor of the bill? We'll have opponents. Anybody against the bill? Neutral capacity. Senator Wayne waives his closing, and there is one letter of support, and that ends LB 23. And we'll return to Senator Wayne for LB 391.
Senator Day. So nobody expects my hearings to go that fast. We'll take a recess until Senator Day comes. Let's take a 5-minute recess.
Senator Wayne, isn't that
Senator Day, welcome. You're welcome to open on LB 391.
Thank you. I appreciate your patience. We waited 40 days and 40 nights for the elevator, but we are here. Good afternoon, Vice Chair DeVore and members of the Judiciary Committee. My name is Jen Day, that's Jenday, and I represent Legislative District 49 in Sarpy County. I'm here this afternoon to introduce LB 391, which would send a clear message to women in our state that they do not need to fear the government, that the government will prosecute them based on the outcome of their pregnancy. LB 391 would do this by providing for criminal and civil immunity for any woman whose pregnancy results in any outcome that does not result in a live birth. This assurance of immunity is consistent with existing law relating to abortion in Nebraska. Section 28.328, subsection 3, Section 28.347, subsection 3, Section 28.3.108, and even Section 6 of LB 626 all provide that a woman shall not be subject to prosecution or be liable for violating laws relating to abortion. This bill is necessary to assure those who are pregnant but need necessary maternal care that they will not be investigated or prosecuted for miscarriages or self-attempted abortions. Women should not fear being investigated or questioned when they seek health care or go to the hospital. Unfortunately, this has not been the case nationwide, and we have seen hundreds of cases of women being investigated and in some cases even prosecuted for pregnancy outcomes. In Louisiana, a woman who went to the hospital for unexplained vaginal bleeding was imprisoned for over a year based on charges of second-degree murder before medical records revealed she had suffered a miscarriage at 11 to 15 weeks of pregnancy. In Utah, a woman gave birth to twins. One was stillborn. Healthcare providers believed that the stillbirth was the result of the woman's decision to delay having a C-section. She was arrested on charges of fetal homicide. In Iowa, a pregnant woman who fell down a flight of stairs was reported to the police after seeking help at a hospital. She was arrested for attempted fetal homicide. Each of these examples is horrifying, and most of these types of charges have been brought under laws meant to punish those for crimes against pregnant women, yet instead were turned around and used against pregnant women themselves. No Nebraska woman should have to face this kind of dystopian prosecution. However, even beyond this, there is new urgency to pass these protections. In June of 2022, the United States Supreme Court issued its decision in Dobbs versus Jackson Women's Health Organization, which overturned Roe versus Wade and Planned Parenthood versus Casey, and related cases affirming the right to abortion. The Dobbs decision reversed nearly 50 years of jurisprudence that recognized a right of people to make individual healthcare decisions, including a woman's qualified right to terminate her pregnancy. Dobbs did not outlaw abortion. Dobbs did not hold that states could not protect the right to privacy in state laws or constitutions. And Dobbs did not say that the state could not protect women from prosecution or civil suit if the state regulates abortion. There is significant confusion as to the status of abortion in this country. This confusion and misinformation is prevalent most acutely in the population who needs maternal health care, the young, the poor, those who are victimized. They do not understand or appreciate the discussion raging in news and social media about abortion, abortion restrictions, and prosecutions for violating abortion law. Compounding this is the problem of many not having access to accurate healthcare information. We have already passed similar immunity provisions to encourage people to contact authorities in drug or alcohol overdose sections in 28.472, 28.470, and 53.180.05. This bill is intended to assure people that they will not be in jeopardy if they seek medical care for complications relating to pregnancy.
Passage of this bill will be an additional assurance to those who are vulnerable to some of the policies other states have implemented relating to maternal medicine and what this state seems poised to do. Women in Nebraska are scared. And still, I'm not naive about this subject. I know that reproductive rights are a topic where many people are not going to change their minds because of sincerely held beliefs grounded in personal principle and conviction. But we can all agree that we shouldn't be in a place where a woman fears that her miscarriage will lead to an investigator poking around with the questions of the circumstances. That we're not going to add layers of legal questions on top of the emotion, trauma, and hopelessness of a miscarriage. We're not going to be a state where women have to think twice about Googling where clinics in other states are, for fear this will be brought against them in the courtroom. If we truly believe it when we say we're not going to punish women, LB 391 should be an easy, straightforward yes vote. With that, I'm happy to answer any questions.
Any questions from the committee? Seeing none, thank you for being here. Proponents. Welcome.
Thank you. Chair Wayne and members of the Judiciary Committee, my name is Kelsey Ahrens, KelseyArends, and I am still the Healthcare Access Program Staff Attorney at Nebraska Appleseed, testifying in support of LB 391 on behalf of Nebraska Appleseed. We believe that everyone should be able to access the healthcare they need in their own communities when they need it. Because this bill protects Nebraskans and their access to healthcare, no matter the outcome of their pregnancy, Nebraska Appleseed supports this bill. Access to healthcare at every point in pregnancy is critical to overall health and well-being of pregnant people. Many health conditions and outcomes can affect pregnant people's life and well-being. One of the most critical indicators of the status of maternal health is the maternal mortality rate. Maternal mortality is worsening in the United States, and rates in the U.S. are worst among wealthy countries. Moreover, reproductive injustice based on race has long persisted in the United States. As you've already heard, today, Black and Indigenous people are 2 to 4 times as likely as white people to die during pregnancy or around the time of childbirth. It shouldn't be this way. About 3 in 5 pregnancy-related deaths could be prevented. Multiple strategies can address the maternal health crisis, for example, ensuring access to free or affordable primary care, comprehensive reproductive health care, a diversified maternal health care workforce covered by insurance, and comprehensive postpartum support. Protecting pregnant people from criminal or civil liability based on their pregnancy outcomes can also reduce barriers to healthcare access. Criminal or civil liability based on pregnancy outcomes erodes trust in the patient-doctor relationship and adds barriers to the pregnant person's access to healthcare. When it is unclear whether a pregnant person is likely to face legal consequences for accessing healthcare, they are less likely to seek help when they need it. Especially when there is public confusion about whether a particular action is criminal, many people will reasonably err on the side of not taking the action, chilling their access to healthcare, even if there is no actual threat of criminal penalties. LB 391 will make clear that no pregnant person will face civil or criminal liability for their pregnancy outcome and will therefore reduce these risks and encourage pregnant Nebraskans to seek the healthcare they need when they need it. Nebraska Appleseed is committed to ensuring that all Nebraskans have equitable access to healthcare services, and therefore we support this bill and respectfully ask that you advance it.
Thank you. Any questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent.
Thank you. Scout Richters, SCOUT-RICHTERS, here on behalf of the ACLU of Nebraska in support of LB 391. Nebraskans must have the ability to make the decisions that are best for their own bodies, lives, and futures. Even with Roe v. Wade in place and now in the wake of the Dobbs decision, people across the country are subjected to the criminalization of their pregnancy outcomes. Across the country, all kinds of laws that were never meant to punish people for their pregnancy outcomes have been used to charge and prosecute people, as Senator Day mentioned. These include abortion bans, unauthorized practice of medicine laws, fetal harm laws, and improper disposal of human remains, just to name a few. We often hear from anti-abortion politicians and activists that abortion bans are passed in order to protect pregnant people. But we know that the true goal of abortion restrictions is to prevent people from accessing the health care they need. It is increasingly more likely that, to the contrary of being protected, pregnant people have been and will continue to be at legal risk for their pregnancy outcomes. And this is why passing LB 391 is so important. If, when, how, a reproductive justice organization has studied and reported on criminalization extensively and has found that the majority of instances of criminalization have involved people living in poverty and that people of color are disproportionately represented in charges and prosecutions. Another important point to highlight from this report and for criminalization of pregnancy outcomes is in general is that the consequences of prosecution include losing custody of children, being turned over to immigration for possible deportation, the loss of jobs, having to move, just to name a few. These matters can also have impacts for people involved in the child welfare or criminal justice systems, because not only can criminalization of pregnancy outcomes bring you into those systems, but if a person is already involved in a criminal or child welfare case, they're more likely to be criminalized for their pregnancy outcomes, as they can be under surveillance, including by caseworkers, probation officers, ankle monitors, etc. Given the discrimination that is rampant in these types of cases, the discretion of prosecutors, police, and others who make reports, and the growing threats to pregnant people in the wake of the Dobbs decision, LB 391 is vital to protect Nebraskans and prevent prosecution for pregnancy outcomes. So we thank the committee, and I would be happy to answer any questions.
Any questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent.
Thank you. Good afternoon, Chairperson Wayne and members of the Judiciary Committee. My name is Andy Curry Grubb. It's ANDICURRY-GRUBB. I'm the State Executive Director for Planned Parenthood North Central States, and central to our mission at Planned Parenthood is the conviction that all people deserve to live in communities where sexual and reproductive rights are recognized as basic human rights. And with that in mind, we're proud to support LB 391. I've given you my written testimony, and it's similar to things that have already been said. So I'm going to let you read that on your own, but I do want to make 2 points that have not been made. One is in regard to what Senator Day said in her opening regarding the fear and confusion and concern that folks have around pregnancy in our state is already happening. Abortion remains legal in Nebraska, and yet we are already hearing, we've continued to hear since Roe was overturned, the concerns that people have with how to access the care that they need. So this bill I find incredibly important now, whether LB 626 is passed or not. The other thing I want to make abundantly clear is that this bill protects the pregnant person, and that is all. This is not a protection for anyone else except the person experiencing pregnancy from being prosecuted for outcomes of that pregnancy, whatever they may be. With all of those things in mind and the other things that I have written, I would encourage the committee to advance LB 391.
Thank you. Are there any questions for this testifier? I don't see any. Thank you for being here. Next proponent. Is there anyone else who would like to testify in favor of this bill? Then we'll go to opponents. Is there anyone who would like to testify in opposition to this bill? Neutral capacity. Anyone in the neutral? While Senator Day is coming up for her close, I'll tell you that there were 72 letters. For the record, 53 were in support, 19 in opposition. Senator Day, you're welcome to close on LB 391.
I will make my closing very brief, but I think if we continue to have conversations about restricting access to reproductive health care, whatever that means, we have to make sure that we have protections in place for people who can become pregnant. And
if we want to outlaw abortion or if we want to outlaw specific types of procedures, then as senators, we have the right to do that. But if we want to continue to say that the abortion bans or restricting certain types of procedures is not about prosecuting women and sending them to prison or investigating them for pregnancy outcomes, then we absolutely have to have something like this in place to make sure that we are protecting people who can become pregnant. I'm happy to answer any questions.
Are there questions for Senator Day? I don't see any. Thank you, Senator Day. That will close the hearing on LB 391 and open the hearing on LR 20CA. Senator Conrad, you're welcome to open on your LR.
Hello, good afternoon, Vice Chair DeBoer, members of the committee. My name is Danielle Conrad. It's D-A-N-I-E-L-L-E, Conrad, C-O-N-R-A-D. I'm here today representing North Lincoln's Fightin' 46 Legislative District, and I'm proud to introduce LR20CA. Side note, the first measure that I had before set for hearing in this legislative session was before the esteemed Judiciary Committee. And this is my last bill that I'll be opening on this session before the esteemed Judiciary Committee. So what a nice bookend to my committee activity in 2023. And thank you all for your time and attention to so many important matters, but for your time and attention in regards to this matter today as well. Let me be clear. This measure would simply let the people of Nebraska vote on adding a specific right to privacy in our state constitution. A similar right to privacy is found in many of our sister states' state constitutions, and the proposal is mirrored after those constitutional provisions in our sister states, many of which have very similar history and political dynamics as we have in place in Nebraska. And let me tell you what I think is really important about establishing a specific individual right to privacy. An individual right to privacy has been found and has been well established as part of our common law, as part of our state statutory schemes, as part of our state constitutional and federal constitutional provisions and subsequent court decisions detailing what those substantive protections mean for Americans. And this is something that I think is just inextricably intertwined with who we are as Americans. We value, hold dear, and we require a right to be left alone, particularly from a tyrannical government. And we've seen this issue play out in many instances. Marriage, the protection and fundamental rights surrounding family and child rearing, education, government censorship, and it also extends to reproductive rights and LGBTQ rights and police practices and mass surveillance as well. So I think that it's very important that Nebraska voters have an opportunity to weigh in on this measure. There's no fiscal note. It encompasses a variety of key concepts and issues to provide better and clearer protections for individual rights, liberties, and freedoms against government overreach. So I'm happy to answer any questions, and I'm looking forward to the testimony today.
Are there any questions? Senator Geist?
Yes.
So if it encompasses all of that,
It
how
does.
would the voter know exactly what they're voting for?
Yes, I have great confidence in the voters of Nebraska to make intelligent decisions about what's on their ballot. And I think Nebraska voters know very clearly what a right to privacy does mean for them and their family. It means the right to be left alone.
But do you think that the average voter, and not imputing their intelligence at all, would understand the extent of what you just outlined? It means from the entirety of what you just said?
Yes, I do. Because I think that the average Nebraska voter is an average Nebraskan who recognizes and understands that government shouldn't be nosing around in the most private, intimate aspects of our life when it comes to how we raise our children, when it comes to our relationship with our spouse, when it comes to the type of information that we read, when it comes to overreach by police practices of mass surveillance, when it comes to matters of reproductive rights, when it comes to matters of intimate relations. Yes, I think Nebraskans absolutely understand that government shouldn't be over involved in the intimate aspects of our lives.
Well,
I think
I'm not questioning that, whether they would think that. I'm just questioning whether, if saying that this is an individual right to privacy, because it has to be very specific on the ballot, if they understand in saying that it encompasses that huge list that you just said. I'm not sure everybody's going to think that without having a big education process to say, here is what that all means. And that's my question.
Yeah, I mean, that's part of why we're building a record today, right? It would be part of the legislative history if this measure is referred to the people for a vote, and it would become a part of our Constitution. It would also be part of a campaign, like any constitutional matter that is referred for the vote of the people would be by parties on all different sides of the issues to say, vote yes on this because of X, Y, and Z, or vote no on this because of X, Y, and Z. That would absolutely be a part of the process, I think. And I think what's also important to know, Senator, is two things. We don't actually have to do a lot of guesswork about this because, again, we have clear examples in I think at least 10 of our sister states that have a specific right to privacy, so that we really know what we're talking about. And it touches upon those different areas of private life, which I've already mentioned. The other thing is I would just point the specific text of the language isn't an absolute right to privacy. It allows for an infringement when there is a compelling government interest.
Okay.
Thank you, Senator Geist.
Senator Blood. Thank you, Vice Chair DeBoer. Thank you for bringing this in. I have to be honest and tell you that we were bombarded with emails that all said the exact same thing.
Okay.
And I think that there is a disconnect in the fact that people are being encouraged to say that there's not enough language in this to be understood.
Oh, okay.
So the question that I have, I'm just letting you know where I'm coming from.
That's helpful because nobody had shared those emails with me.
Yeah, nobody ever answered my questions, I'd like to point out. I'm like, well, what about the language do you not like? So when you talk about, what is the word, compelling, help me out here.
Yes.
Compelling state interest.
Mm-hmm.
Doesn't that mean that it's essential or necessary instead of like it's a choice or a preference or discretion? That's what it means legally and why it's used in an LR, because that's something that you would do in any state when describing something like that. Would you say that that language is consistent with what an expectation, consistent with our expectation of what we would see in a legislative resolution at any state that was going on the ballot pertaining to something like this?
Yeah, absolutely. Thank you, Senator Blood. And, you know, the first piece I'll just be clear about is that it is very brief in design, right? It is a very straightforward concept. People have a right to be free of government overreach in their private affairs, period.
An individual privacy.
An
We're talking about
individual privacy. An individual
So
privacy.
that's the clarification that that would be my comprehension. And hearing what you've heard about the emails, would that be your comprehension that people are trying to expand it beyond individual privacy? They're saying, oh, privacy, what does that mean? Does that mean what happens behind closed doors? Does that mean what happens in public? It's more, even more narrow than that. It's more what happens to you, right?
Yeah, and again, I haven't seen, I don't know if some interest groups sent out an email blast or something, and now that's being parroted as part of the committee hearing today, but that's okay. I welcome all questions to the debate. The measure itself was drawn upon an almost identical measure in the Montana Constitution, almost verbatim. So we have a good understanding and track record of how that has been applied in a sister state with a very similar political landscape.
When was that done in Montana?
perhaps at founding. I'll go back and double check to see when it was adopted, but I believe that it's been on the books for decades, if not hundreds of years. I can go back and double check on that. The other piece, Senator Blood, to your question is, you're absolutely right, where it is not an unfettered right to privacy. It is a right to personal privacy that can only be infringed if there's a compelling government interest. So this is the well-established, long-established legal framework for fundamental individual rights, just like free speech. Let's think about it in a free speech context, right? We have the right to free speech, free expression, association, the right to petition your government. Congress shall make no law, right? Even that is not absolute. Government, of course, passes laws all the time, and they're only permissible if they're content neutral, things like time, manner, place restrictions, right? So the only way that the government can infringe upon a fundamental right is if there's a compelling state interest, for example, right? So it's not anything goes, anytime, individual freedom. If there's a well-established, clear, compelling interest, then government can infringe upon the individual right to privacy.
So essential or necessary.
That's right.
I don't mean to talk over you.
Yeah, it's a high bar. Yeah.
Thank you, Senator Blood. Other questions? Senator Conrad, what is the process for this LR going forward? So if we were to put it out of committee, then what would the next step be?
So Nebraska, not all states have initiative and referendum. Nebraska is, I think, one of about 20-ish that have different forms of initiative and referendum. In Nebraska, we have, of course, the citizen initiatives, right to proactive initiative and referendum. We also have the ability to do a citizen referral or a CA that's referred by the legislature to the people. So if advanced from committee and works its way through 3 rounds of the debate, it does not go to the governor's office. It goes to the people for an up or down vote. It takes 30 votes to get there, so it's a heightened standard. And then if it passed through the legislature 3 rounds of debate with 30 votes on final, then it would go to the next general election ballot automatically, and the people would have the right to say, this is a good idea or a bad idea to put this into our state constitution.
So then, regarding the concern about potential vagueness in the language, I mean, what safeguards are there against the non-education of the voter in Nebraska with respect to candidates or referendum or anything like that? I mean, how would this be different than voting for, say, a candidate that you don't have information about, but a first and last name on the ballot?
Yeah, I think that's a fair point. So a couple of things. So one, we don't really get to things like legislative history if the words on their face are clear, which here I believe that they are. I don't believe that they are vague or unclear. So I think that's where you would stop your inquiry in regards to this matter. If, for example, at some point a court were to find that the language itself as adopted by the people was somehow ambiguous or vague, then you would default to the legislative history to ascertain the meaning. The legislative history in regards to a referred CA would be this process and the campaign process. You'll note that anytime that we have ballot initiatives before the people, we have a variety of different mechanisms that help to inform the vote. We have ballot title language written by the Attorney General. We have congressional hearings in each congressional district. We have a pamphlet put forward by opponents and proponents that provide additional context to the vote. That all becomes part of the legislative history in initiative and referendum.
Okay, thank you. Are there other questions? Thank you, Senator
Thank you.
Conrad. First proponent.
Good afternoon, members of the committee. My name is Spike Eichholt, S-P-I-K-E. Last name is E-I-C-K-H-O-L-T. I'm appearing on behalf of the ACLU of Nebraska in support of the proposed legislative resolution. You've got a copy of my testimony. I think what Senator Conrad intends with this, as she explains, is that this is to provide for a referendum question or a question to the voters as to whether they'd like to have an established right of privacy in our state constitution. If you look at my testimony, I talk about one component of the individual right, and that is the right for reproductive freedom. But I think if you kind of remember some of the bills that you heard earlier today, some of the issues, or today, this session, I should say, and some of the other issues, I think what Senator Conrad explains is right, that there is sort of a growing sense, or at least a sense among the people of the state, that government should be out of their lives. And you see it in a variety of different ways. Remember that bill that we had dealing with license plate reader systems that would provide for companies to collect and harvest data that's obtained by people sort of just driving through the city. I don't know if we heard any anti-masks or any anti-vaccine bills, but you saw some of those bills introduced and heard in other committees. These things are coming up organically throughout the state. And then, of course, another sort of concept of individual privacy is the right to reproductive freedom. Senator Day's bill that we heard earlier today talked about the history of Dobbs reversing about 50 years of precedent in the state. And what Dobbs said, as Senator Day explained, was that there is not an individual right of privacy in our federal constitution that provides for the right to abortion. Now, other states have interpreted their constitution to provide for a right to privacy, or at least an individual right to abortion. And some of those states include Alaska, Arizona, California, Florida, Kansas, Massachusetts, Minnesota, Montana, New Jersey, and New Mexico. So we do have a general right of privacy already in our state constitution, but our courts have never interpreted that to be anything broader than what the federal right of privacy provides. A couple of states have interpreted their constitutional rights to equal protection to provide for a right of autonomy to make healthcare decisions, and included that would be New Mexico as an example of that state. But I think what Senator Conrad's got here proposed would put this issue back to the voters, if you will, and let them decide whether in our Constitution there is an individual right of privacy that could include something like reproductive freedom and other rights. I think if you look at some of the polling data that I cite, not only from the ACLU Nebraska, but also from the Holland Children's Movement, people generally are consistent in Nebraska when they say that they do not want government controlling their healthcare decisions and their right to make decisions with respect to whether to become a parent. And I think this issue should go before the voters. I'll answer any questions if the committee has any.
Are there any questions, Senator Grice?
I'm curious, as I read your testimony, and would this, if, let's say this goes to the ballot, this passes, lifts all restrictions on abortion? Would this lift all restrictions on abortion?
I don't think so, because as Senator Conrad explained before, what this provides for, if the state can show a compelling state interest, then restrictions can be imposed. And that's similar to some of the language that you saw in the Roe versus Wade decision in Planned Parenthood versus Casey, where you have sort of a balancing of issues, where the courts recognized that the states did have a right to protect viable fetus life, for instance, or they did have a right to protect and provide for some regulation during some terms of the pregnancy.
So would that have to be put in statute, or would it reflect what's already in statute, or how would that work? How if there is a right to privacy and a right to, I'm just going to say, a recognized right to abortion and health care has the state's guarantee of equal protection of the law, then how specifically after this would pass on a ballot initiative, how would there be in any other way a restriction?
I think if I
Would
understand.
that be statutory, or would it, go ahead.
No, I'm sorry. I don't
No,
mean to interrupt.
go ahead.
If the voters approve this, and this would be an individual protection in our constitutional Bill of Rights that would provide people with the right of individual privacy. The state could still have some authority to regulate that right, as Senator Conrad explained, just like they have on any other sort of right that we already have.
Under the, and I'm, just so I understand, under the compelling state interest. And so I hate not being an attorney, so I can like figure all this out.
Well, it's not much of a day at the beach
you
being white,
guys.
I'll tell you.
But I don't, I guess then who stands up for what compelling interest
Right.
is argued for the unborn child at that point?
Well, that would be something that the voter or that the representatives could still pass laws on. For instance, we already have a pretty broad right to possess a firearm in Nebraska. We have a couple constitutional references. It's the very first Article 1, Section 1. But we have all kinds of laws on our books restricting the right to possess firearms if you're convicted of a felony, if you're convicted of a domestic violence offense, that kind of thing. Similarly, again, I can't speak for what Senator Conrad necessarily means with this proposed amendment, but if it was to be adopted by the voters, that would not preclude the legislature of Nebraska from passing laws regulating abortion, so long as the state could show a compelling state interest in doing so.
Okay. All right, thanks.
Thank you, Senator Geis. Other questions? So, Mr. Eckwell, if this were to pass, then ostensibly figuring out some of these, the rules around the right to privacy would be a judicial. I mean, we could pass statutes.
Right.
I think this is maybe what Senator Geis was asking about. We could pass statutes, and then they would either meet the judicial scrutiny of a compelling state interest, or they wouldn't.
Right.
But the judicial process would be to go through it. Or there would be sort of a common law question about whether or not already existing or future existing concepts would be within the constitutional provisions, just like any constitutional provision that is pre-existing, right?
Right.
Is there any difference between a pre-existing constitutional provision and a latter existing constitutional provision?
I think Nebraska courts would likely interpret, if the voters approve this, they would likely not just review it and decide it was just surplus language. I think they would have some recognition or recognize that the voters meant to do something with doing this. I don't think the world will come to an end. If you look at Article 1, Section 3 of our Constitution, there's a phrase that was added in 1997, quote, "nor be denied equal protection of the laws," end quote. We adopted in 1997 a constitutional amendment in our Constitution to provide for equal protection of the laws. There was some litigation after that was going to provide for some sort of super equal protection that was greater than the federal, and the courts really didn't read that in there. The courts in Nebraska, I think, are pretty modest in overly interpreting provisions in our Constitution. They usually follow the federal Constitution scope of protections for their individual rights and what other states generally do. I don't know if that was responsive to your question necessarily.
No, it is. So there's sort of two ways in which this would get meted out as to how it really applies. Would be one, through whatever statutory provisions that we all put in place, or whoever was in the legislature at the time put into place, and then also whatever the courts determined we meant by the provisions that then were adopted by the voters, and so then they meant by them. So
That's right.
it would be both through the judicial process and through the statutory process.
That's right. And it would be, if I could just supplement, it would be interactive. If the voters approved this and the legislature wanted to amend a law to provide for some sort of abortion regulation, the legislature could always just reference this. That's exactly what Senator McKinney did earlier this year on one of his prison bills, was reference a provision in our Constitution said pursuant to article something, section whatever, the legislature declares as follows. So it's not.
It wouldn't provide something that the legislature or the courts together didn't want. It would allow the people to instruct the courts and the legislature of the kind of thing that they wanted. And then it would be up for the court to determine whether we went too far as a legislature. Okay. All right. That's all the questions I have. Are there other questions?
Question from the committee? Gina? All right. Next opponent. Pro opponent. Sorry, I thought Senator Conrad was bringing a new penalty and Spike was against it, so I was confused. Welcome.
Chair Wade and members of the Judiciary Committee, my name is Kelsey Ahrens, KELSEYARENDS, and I'm the Healthcare Access Program Staff Attorney at Nebraska Appleseed. So we came at this bill from a healthcare perspective as well, because this resolution will protect Nebraskans' right to privacy in many important areas, including in their healthcare. Nebraska Appleseed supports this resolution. State Supreme Courts in other states have interpreted the right to privacy in their state constitutions to protect things like access to abortion. Access to reproductive health care services is a critical part of overall health and well-being. Research shows that protecting the right to reproductive freedom reduces childhood poverty and increases the likelihood of educational attainment. Conversely, restrictions on access to reproductive services, including abortion services, have detrimental and disproportionate impacts on those experiencing poverty and perpetuates generational poverty. Being denied an abortion quadruples the odds that a new parent and the child will live below the federal poverty line, and public assistance programs are not sufficient to recover from the cost of a new baby. I'll go ahead and keep my testimony short and leave the rest for you to read, but because Nebraska Appleseed is committed to ensuring that all Nebraskans have equitable access to healthcare services, we urge your support of this resolution.
Any questions from the committee? Okay, Senator Gay.
Thank you. What is the difference between this right to privacy now and existing HIPAA laws that are in place already?
That's a great question. So HIPAA, my understanding of HIPAA is that it applies just to health entities. So covered entities are required to keep patient information private. This right to privacy, number one, would be much broader, just in all the different areas of different rights that it would protect, as Senator Conrad explained, but in the healthcare space too, would protect an individual's right to privacy more broadly than just protected health information in the healthcare entity setting.
Thank you.
Any other questions from the committee? Seeing none, thank you for being here.
Thank you.
Next, proponent. Next proponent. Ready. First opponent. Welcome back.
Thank you very much. Excuse me. Good afternoon, Senator Wayne and Chair Wayne and members of the Judiciary Committee. My name is Marion Miner, M-A-R-I-O-N-M-I-N-E-R. I'm Associate Director of Pro-Life and Family Policy for the Nebraska Catholic Conference. The conference opposes LR20CA, which was introduced on January 11th of this year, the same day that there was a press conference to announce the introduction of what would become LB 626, the Nebraska Heartbeat Act. LR20CA seems to clearly be a response to that announcement. It's meant to insert a right to abortion in the Nebraska Constitution. When Roe v. Wade was passed down by the U.S. Supreme Court in 1973, the basis for a supposed right to abortion in the U.S. Constitution was what the court deemed an individual right to privacy. That was the basis under which they found a right to abortion. The same right LR20CA would insert into our Constitution. Courts in other states, by the way, have used the right to privacy to find, or advocates have used the right to privacy, the existence of a right to, an explicit right to privacy in their state constitutions, to argue for a right to abortion in their state constitutions. The court in Roe held that this right to privacy included a right to elective termination of pregnancy, which had the effect of invalidating the laws protecting human life in all 50 states across the United States, despite the wills of their state legislatures. This right to abortion, in the court's view at the time, meant that protecting a baby's life was not a compelling enough reason to warrant any restriction on abortion at all until after the first trimester. Before the end of the first trimester, babies are known by the science of embryology to develop a face, fingers, toes, and a beating heart. Abortions, however, under Roe were to proceed, quote, free of interference by the state, close quote. According to Roe, during the second trimester, about 12 to 28 weeks into pregnancy, states could regulate the practice of abortion to the extent their laws were reasonably related to protecting maternal health, but not to protect the lives of preborn children. After the point of fetal viability, considered at that time to be about 28 weeks, the court held that the state's interest in protecting human life became compelling, and that the state could enact laws that had as their purpose the protection of human life from abortion. Even those laws are subjected to a skeptical eye by the courts to be disregarded if any doctor asserted any factor of a woman's health to include, quote, physical, emotional, psychological, familial, meaning family size or income, or the woman's age, close quote, would be negatively impacted without an abortion. The result was a near total right to abortion through all 9 months of pregnancy. That's the history that we have to keep in mind when we're talking about inserting a right to privacy in the Nebraska Constitution. That's how it was interpreted by the courts in Roe v. Wade. And I see I'm out of time. I did have more to say, but I will end there.
Thank you. Any other questions? Senator Grice.
Thank you. I think that so the compelling state interest doesn't really, according to what you said, doesn't begin until about 28 weeks, but could extend all the way to the end under different provisions. Is that?
So it depends on how a particular court interprets that. So what is compelling enough? What type of state interest is compelling enough to override the general constitutional right? And a compelling interest is essentially just about the highest bar that you have to clear to show. In this circumstance, the state has the right to intervene. So when we're talking about the state having an interest in protecting preborn human life, our history shows in interpreting Roe and its follow-up cases that essentially the state has no right at all to intervene until 28 weeks, essentially. Now, in Nebraska in 2010, just in 2010, I mean, this is pretty recent still, but in 2010, Nebraska passed its 20-week law, which at that time was considered extremely bold because it really cut directly against what Roe and Casey had established. And it was trying to establish a new compelling interest to show that babies feel pain at that point in pregnancy, and that therefore the court should take that into account as a potentially compelling interest.
Is viability a compelling state interest?
That was the judgment of Roe and reaffirmed by Casey. They said viability is the point where the state's interest in protecting human life becomes
But isn't
compelling.
that getting lower and lower?
Sure. So at that time, it was considered to be about 28 weeks. It's more common now for babies to survive. They're born at 26, 24 weeks, even a little bit earlier sometimes. So it is kind of a moving target. Excuse me. But the fact remains, our history shows in the Roe and Casey abortion context that essentially you've got an almost unlimited right to abortion up to at least fetal viability. And if you can find a doctor that says that, well, your family's too big or your income's too low, that relates to your maternal health. Therefore, that becomes the exception that swallows the rule, and it becomes an unlimited right to abortion. That's the history that has been around a similar conversation in Roe and Casey at the federal level.
Thank you.
Any other questions? Seeing none, thank you for being here.
Thank you.
Next, O'Connor.
Good afternoon, Chairman Wayne and members of the committee. My name is Nate Graz, N-A-T-E-G-R-A-S-C. I am the Policy Director for the Nebraska Family Alliance, and I'm testifying in opposition to LR20CA on their behalf. This proposal seeks to provide a pathway for establishing a right to privacy in the Nebraska Constitution. While the statement of intent lists matters such as free speech and government surveillance for why this is necessary, it is not lost on us, nor should it be lost on the committee, that the U.S. Supreme Court used a right to privacy as the basis for their ruling in Roe versus Wade, as Mr. Minor talked about, which legalized abortion through all 9 months of pregnancy. Creating a right to privacy in our state constitution is another way of creating a right to abortion, and could be used to allow babies who are fully formed and can smile, yawn, and feel pain to be aborted for any reason. In the 50 years since Roe was decided, science and technology have advanced dramatically. We can see clearly in 3D and 4D ultrasounds that an unborn child in the womb is not just a clump of cells or a blob of tissue, but an individual human being with their own unique DNA, deserving of love and protection and the right to live. Nebraska Revised Statute 28325 states that the will of the people of Nebraska is to provide protection for the life of the unborn child whenever possible. With Roe now overturned, rather than seeking to create a new right to abortion in our state constitution, the state should seek to provide greater protection to the lives of baby girls and boys in our state. We urge the committee to support our most important and fundamental rights, the right to life, and not advance LR20CA. Thank you.
Any questions from the committee? Seeing none, thank you for being here. Next opponent. Seeing none, anybody? You can fill it out when you get done.
Apologize for that.
Welcome.
My name is Scott Thomas, SCOTTTHOMAS, Built in Progress.
Speak up just a little bit.
Okay. SCOTTTHOMAS with Village in Progress. I'm going to oppose this on the grounds of Article 3 of the 1948 UDHR that protects life. And I'd say, like, as a father too, I got an 11-year-old girl, and so people, when they talk about abortion, they ask, would you want your daughter's rights to this and that protected for it? And I gotta be honest, man, like, she learned in kindergarten because they had a salad bar in the school that she went to. She went to a private school, and her teacher would instruct her that when you finish your tray, you can go up and you can get something off the salad bar that's a choice. You make a choice, you pick something, you eat it. And so she knows about making choices, like even at a young age. So I think, we make certain choices. And I think, like, also, like I said, my mother made choices. I wouldn't be here. Was it Ronald Reagan that said that everybody that's for abortion has already been born? So, like I said, I got to come down as a parent and as a human rights consultant on the side of life on that one. Any questions for the senators?
Any questions? Senator Blood.
Thank you, Chair. I'm not sure, can you better explain to me why you feel the way you feel about this bill?
I believe that it violates Article 3 of the 1948 UDHR.
In what fashion?
Because it violates the right to life.
How does it violate the right to life?
Okay, so 75 years ago, following the war to end all wars, a bunch of people came together to determine 30 enumerated human rights chaired by our First Lady then, Eleanor Roosevelt. And in these 30 enumerated protected human rights by international treaty, Article 3 is the one that's assigned to protect life.
But wouldn't you say that privacy is also a civil right, one that has excluded brown and black people, people with disabilities, immigrants?
I would look at civil rights as an issue of determinants for government. And I think that human rights supersede those. Human rights would be like what you're endowed with.
I'm sorry, I have trouble hearing here.
I said, I think that human rights are separate from civil rights. I perceive that as an issue for governance. And I would look at human rights as the rights that you're endowed with by your creator, inherent to your humanity.
But we're talking about privacy rights. You don't believe that privacy is a civil right? It's not a trick question. I'm like really trying to clarify.
I'm trying to needle it out. I'm trying to follow where you're going with it, but okay.
Like,
So
you have the right to determine what information is collected about you. Do you feel like you should have that right?
fair enough. Depends on what the information is, right? So we talked earlier about, I heard a reference to compelling state interests. And I'd say like the fact that we are having issues with our repopulation rate, which will affect our GDP, which will affect our social security programs and all subsequent programming. I mean, we have issues that threaten our economic stability as a country. And those could be rooted in the Roe v. Wade decision, according to like Mother Teresa filed an amicus brief with the Supreme Court, and that's what she said, that this decision has pitted the interests of the mother against the child. It's not necessarily productive for society.
So I think that maybe the disconnect for us is that you're talking specifically about abortion.
Protecting, yeah, I'm specifically talking about protecting
And
the
this
right to
is
life.
a
And
bigger
there's other things
encompassing bill.
contained in the bill. I understand that. Yes,
Okay.
ma'am. I apologize for
No,
that.
don't apologize. I
Okay.
just am trying to clarify and learn better what you're thinking. So I appreciate you.
Okay. I hadn't intended to testify. I hadn't
No,
filled out
that's
a
all right.
green sheet or anything like that. It was just kind of compelling what I heard said.
I'm going to be asking the presenter, does she wave?
No, she's right there.
I'm going to be asking her the same question. So thank you.
I apologize if I wasn't clear.
Don't
on that.
apologize. Thanks
All
for
right,
coming in.
Good day. Anything else?
Make sure you fill out the blue form. Nope. Thank you for being here. Next, opponent. Anybody testify on the neutral capacity? As Senator Conrad comes up to close, we had 63 letters, 48 in support and 15 in opposition. Senator Conrad.
Thank you so much, Chairman Wayne. Thank you, members of the committee, for your time, consideration, and good questions. Let me just put a fine point on it. I absolutely respect the right of the Catholic Church to live out their authentically held religious beliefs and to participate in this process. However, I do not believe that their individual religious beliefs should set the course for policy for all in Nebraska. I respect the right for them to hold their beliefs. I respect the right for them to participate in this process. I'm grateful that they take up a variety of different issues, but let me be clear. My impetus in bringing forward this legislation is to push back against that kind of government overreach and that kind of theocracy that's been put forth by that kind of advocacy. Government, under the guise of religion or otherwise, does not belong in our bedrooms. It does not belong in our doctor's office. It should not be keeping watchful tabs on what we pick up from the library or what we research online or the intimate relations we have with our life partners. It should not get to dictate how I raise my children in my home. We should get out in front of the ever creeping grasp of technologies involved in mass surveillance and otherwise that infringe upon our right to individual personal privacy. We can absolutely have different beliefs about the role of government, but mine is fairly libertarian. Individual rights and freedom and liberty should take the lead, not government overreach. Happy to answer any questions.
Senator Black.
Thank you, Chair. Senator Conrad, you heard me ask.
I was hearing most of
It's
it.
so
I
hard to
wasn't
hear
hearing
you.
all of it. So if I could ask perhaps for a repetition just to make sure I have it right. I heard a discussion perhaps between the difference in civil rights and human rights.
No.
Okay.
That was the interpretation on the other end.
Okay.
And I'm going to try and read my messy handwriting because I was writing some notes down when Spike was
Okay.
talking. So it's kind of a multi-part question.
Okay.
So the first part is, do you believe that privacy is a civil right? And the reason I say that is that we know that in our, can you hear me okay? In our Black and brown communities and people with disabilities and our migrants and immigrants and others, that discrimination has continued to be brought forward through like commercial data and
Yeah.
surveillance practices, which is the thing that Spike made go in my head, and I blame him, by the way. Do you feel that we have the right to determine what information is collected on us and how it's stored and how it's used? I keep seeing these bills that are talking about technology that show me personally they don't have a clear understanding of how technology works for starters, and they want to come to this committee and say we want to give people more time for doing crimes that are already in state statute, and I feel that I am getting to questions. So
No,
privacy
no,
is
it's
the first one.
helpful.
And I feel like I'm on a roll. I feel like if we can put this into the Constitution, then we have the foundation to get smarter policy when it comes to things like surveillance and commercial data.
Yes.
I mean, I always think back to when people were like, I can't believe Facebook is selling our data. It's like, how did you think they paid for it, dummy? You know,
Right,
I mean,
right.
like, come on. So those are the questions I have for you. So privacy is a civil right.
Yes.
And
Should
you
be.
feel that people have the rights to know what's being done with their information and the surveillance. And you feel it will be a good foundation for future legislation.
I think the answers are yes, yes, and yes.
All right, that's too easy. Why though?
Why though? Because I think it goes again kind of to our fundamental understanding of human nature, that we have a right to be free from government overreach. We have the right to be free in our homes, in our persons, in our papers, in our thoughts. We have the right to be free in those things. And those rights should only be infringed by the government when there's a compelling governmental interest.
Thank you.
Yes, thank you.
Any other questions from the committee?
Thank you.
Senator Decay.
Oh, I was almost out of the seat.
I don't think there's anybody in here that's going to disagree that we have the right to have our privacy in some aspects, but where does this go where our rights to privacy and government overreach infringes on the rights of others that might not be protected by those same rights in the privacy of their home or wherever?
Sure. Thanks, Senator Decay. And I think, for example, when you look at the legal history and landscape around the right to privacy, it's not absolute, right? You don't get to say, I'm going to commit child abuse in my home, but it's covered by a right to privacy. It doesn't get to be weaponized that way because there's a compelling government interest to protect the vulnerable children, right? And that comes into play a lot of different ways. So no fundamental right has ever been interpreted to be absolute, including the First Amendment, right? Which is first. So there's always kind of a legal framework that we work within to determine what's permissible in terms of government intervention, dependent upon how highly regarded the individual right is. And if it is a highly regarded fundamental individual rights, the government has to meet the highest standard, compelling government interest. If it's something lesser, the government only needs to make a rational basis showing for regulating in that regard.
With that, with the rights, where does that, with the child or whoever involved in this, how does this right so it doesn't, people that can't speak for themselves, how does this help them? And is this resolution in that regard, is it a little bit too broad where we're trying to go with this to protect the rights of individuals, and not be excluding people that don't have the right to speak for themselves?
Yeah, I appreciate that. Thank you, Senator. And again, I don't think that there's really anything vague about this. I think that there's an example from, I think, at least 10 of our sister states that have similar constitutional provisions that talk about how a similar right has been interpreted in their provisions. I think additionally, when you look at like some of the best known cases when it comes to the right of privacy being found either in our common law or statutes or state or federal constitutions specifically, or on the penumbras therefrom, it's things like the right to raise your children, the right to choose their course of religious belief and participation, the rights to decide how you and your family interact with the school system, the right to utilize family planning services. and the right to marry. And we saw, for example, in the Dobbs decision, and there was a clear concurrence from Justice Thomas, which stated very clearly that he thinks that entire body of case law, including the right to protection for family planning, for marriage, even the criminalization of intimate acts by partners of the same sex, should be revisited by the courts. He was very, very clear about overturning potentially those kinds of precedents which have defined our private life for decades. And I think that should be a huge, scary wake-up call to people. And this measure would directly address this and say, yes, people have the right to use family planning services. Yes, people have the right to marry their partner. Yes, people have the right to engage in consensual sexual acts when they're adults with their partner, if they're with their partner of the same sex. Yes, parents have the right to decide the educational and religious upbringing of their family. Now, if any of those acts were to hurt other people, including the voiceless, then that's when that compelling government interest standard comes in, and the entire rest of the framework of laws that we have available in Nebraska.
So if you were, when you're talking about family planning,
Yeah.
would that include everything from contraception, abstinence, and abortion? Or?
Yes. Yeah, absolutely, because I think it would be absolutely wrong for government to dictate when and if and how a family decides to start or expand a family. Those decisions should belong to the family. So if a family decides to not have a family, to utilize natural family planning, to utilize family planning services, I think that those decisions should belong to the family. Absolutely.
Thank you.
Thank you, Chair Wayne. Just two quick questions during this conversation. Isn't religion, two questions. Isn't religion covered under the Fourth Amendment? And isn't things like our personal business, like contraception, that's a medical, so that would be HIPAA? I mean, I just want to make sure we're not going too far off into the weeds, saying that this bill is going to change anything that's already protected.
Yeah, so there's absolutely a right to free exercise of religion, and there's a right to also to ensure that government doesn't infringe upon religion. So you have actually kind of dueling rights in terms of what we commonly call a freedom of religion, right? So nothing would be disturbed about those rights to worship and worship free from government interference if this measure were to be adopted. And when it comes to things like medical privacy, yes, HIPAA is absolutely in place. This measure would not change that. It really goes into the disclosure of certain aspects of medical records, when that information can be disclosed and to who and how. That's really kind of what HIPAA seeks to regulate. But at the heart of HIPAA is really a lot of what's at the heart of this measure is the right to privacy, is the right to ensure that private medical information isn't just distributed kind of willy-nilly because it's personal. And so it should have incredible safeguards around it.
Thank you.
Yes.
Any other questions?
Thank you so much.
Thank you.
Thanks.
That'll close the hearing on LR 20CA and today's hearings.